Hello, and welcome to another one of Marino Barview's 2-Minute Tips. My name is Mike Marino, and today we're going to be discussing the pre-existing duty rule. The pre-existing duty rule, in plain English, is if you promise to do something you're already legally obligated to do under an existing contract, that's not new consideration. And if you remember, a contract consists of an offer, acceptance, and consideration. So without new consideration, a contract modification under the common law is unenforceable. Now, why does this matter? It protects against coercion. Without the rule, someone could demand extra money or benefits mid-contract for doing the exact same thing they've already promised. Let me give you a classic example. A contractor agrees to build your house for $500,000. Halfway through building, the studs are up, the pipes are starting to get run. The contractor says to you, "I won't finish this unless you give me another $50,000. Now, if you agree under pressure, that modification is unenforceable because the contractor had a pre-existing duty to finish the house. Another example that you may see on a bar exam, a singer agrees to perform at a wedding for $1,000. The night before, she says, "I'll only do it if you pay me $200 more." Even if the bride agrees at that point, the singer cannot enforce that extra $200 because she already had a duty to perform. So let's test this real quick before we get to the exceptions, because after all, it's the exceptions that the examiners and your professors love to test. So suppose a homeowner contracts with a builder to start a new project as soon as the builder finishes a prior job. The homeowner then says, after the contract has been signed, that "I'll give you an extra $20,000 if the builder starts on time." Is the modification in this situation enforceable? Take a second, think about the rule we just described it. And the answer is no. Under the common law, the builder already had a duty to start on time. No new consideration, so the modification fails. Now, as I mentioned, it's the exceptions to the rule where this all gets interesting. So there's 4 major exceptions. The first is unforeseen difficulties. That's where if something unexpected arises that neither party assumed the risk for, in that case, a modification can be enforceable. An example is you hire a contractor to dig out your basement. Nobody knew there was bedrock underneath the house. Removing it's going to require expensive jackhammers, extra labor. Therefore, paying extra here would be a valid modification because the difficulty was unforeseen. The second is an honest dispute. If there's a good faith dispute about the contract terms, a modification to settle that dispute counts as valid consideration. Even if one side is wrong, the compromise itself is enforceable. The third is the pre-existing duty owed to a third party. And this one is a little bit complicated, so there's a twist here, right? If I already owe a duty to somebody else, but I promise to perform that duty for you, that would be new consideration. An example would be a truck driver has a duty to deliver supplies for his employer, driving from one place to another, and on the way a hitchhiker stops him and offers him $300 to ride along. At the end, when they get to the truck driver's original destination, the driver can still enforce that $300 deal if the hitchhiker wants to get out of it, because his pre-existing duty was not to the hitchhiker, it was to his employer. The fourth and final exception are avoidable obligations. That's a promise to perform something that could have been avoided, like a minor ratifying a contract at a majority, can be enforced even without new consideration. Now, I keep mentioning the common law, and that's because the UCC, which is governs the sale of goods, the pre-existing duty rule doesn't exist. So you really need to pay attention when you're doing a contracts question. Certainly make sure there's an offer, an acceptance, and consideration. But under the pre-existing duty rule, also make sure that the UCC does not apply. Contract modifications are enforceable if made under good faith under the UCC. Consideration for those is not required. So please pay attention to whether the UCC applies. So are we always going to ask, are we in the common law or the UCC? The answer will change depending upon the outcome to that question. So let's just wrap up with a very simple question so you understand the pre-existing duty rule as it will appear on your exam. A wrestler's agent negotiates a cereal deal, giving the agent 30% of that deal. Later, the agent and the wrestler orally agree that 50-50 would be a fairer split. Is that new agreement enforceable? The answer is no, it's not. The agent had that pre-existing duty at 30%. There was no new consideration for that 50%. So even if both sides had good intentions, the pre-existing duty rule will enforce that. So in closing, That is the pre-existing duty rule. If you have any questions about this rule or any of our other 2-minute tips, or really anything to deal with law school or the bar exam, please don't hesitate to reach out to me or my office. We are always happy to help. Uh, Good luck.